Chapter 20, Other Real Actions, Sec. 102. Real Actions at Common Law. A real action is one brought to recover the freehold in lands, tenements, or hereditaments claimed either in fee simple, fee tail, or for life, by one who is divorced, against him who is tenant thereof. According to the ancient conception of such action, the chief real actions in feudal times, it will be remembered, were for the recovery of the possession of freeholds, and they were classified according to the nature of recovery demanded and granted. The class of actions wherein land and incorporeal hereditaments were recovered, were regarded as pure real actions, while those in which both the land and damages were recovered were classed as mixed actions. Real actions were again classified according to the nature of titles, into proprietary and possessory. In proprietary actions the complainant based his action upon absolute right of ownership, while possessory actions rested upon mere right of possession. It does not seem necessary to trace the history of the law concerning the essentials to a complete title or the theories upon which mere possessory titles rested in order to explain the old common law actions. It is only necessary to note that the remedies were so constructed to meet the requirements of the various rights in real property as determined by substantive law. Proprietary actions were divided into 1. Writs of right, and 2. Writs in the nature of writs of right. There were 4 kinds of proprietary writs of right, while there were 18 of those in the nature of writs of right. There were about 20 possessory real actions. There were about 60 real actions altogether, all of which were technical and expensive to litigants, and were abolished by an Act of Parliament enacted in 1833, excepting the writ of right of dower, quaere impedit, and ejectment. Sec. 103. The real action in American states. In some states the action in which title and the consequent right of possession are determined is designated as ejectment, or an action for the recovery of the possession of real estate, in which action the plaintiff must show legal title and right of possession. As one writer puts it, it would perhaps be more accurate to say that an action in the nature of ejectment prevails in most of the states for the trial of title to land, and that it is substantially governed by the principles which for centuries supported the common law action of ejectment. Trespass to try title was the form of action to determine the question of title adopted in South Carolina, Alabama and Texas, although changes in name and nature have since been made. The ancient possessory action of writ of entry in modified form was adopted in Massachusetts, Maine and New Hampshire. Sec. 104. Writs of dower. The right known as the wife's right of dower was purely legal, and was asserted at law through the writ of right of dower, and the writ of dower and nihil habet, both of which were in the nature of real actions. As early as the reign of Queen Elizabeth, courts of equity began to assume jurisdiction over cases of dower, but only tentatively, and as ancillary to proceedings at law. This jurisdiction, originally narrow and auxiliary, has, by the course of decision, and on familiar equitable principles, been expanded to the extent of affording complete relief between the parties. The writ of the right of dower was a writ pursued by a widow at common law, who had acquired from the tenant by assent her dower in only a parcel of the land to which she was entitled to be endowed in the same time, and was divorced by him of her dower in the residue. It fell into disuse by reason of the remedy afforded by courts of equity. Sec. 105. Dower. Equitable jurisdiction in resort was had to equity in the assignment of dower because of the impediments in the way of recovery at law. As the title deeds to real estate were held by heirs, devisees, or trustees, it would be important, and even necessary, for the widow, on the event of a contest of her dower, to resort to equity, for the purpose of ascertaining the lands of which her husband had been seized during marriage. To accomplish this purpose, a bill of discovery would be entertained in equity, and where the land of the husband was an undivided interest in a greater portion, equity would decree a partition in aid of the assignment to the widow of her dower. This jurisdiction was, in its early stages, strictly auxiliary, and if no obstacle in the way of recognition and assignment of dower at law was disclosed, the equitable proceedings would be arrested. The equitable jurisdiction, having once attached, was not slow in maturing so as to confer full relief. When the widow came into equity for a discovery respecting the title deeds to her husband's estate, which were in the hands of the heir, it was held that she should have complete relief. If her title to dower was denied, it would be incumbent upon her to establish such title at law. Equity would, for that purpose, retain the bill for a reasonable time, and upon the determination of the issue at law in the widow's favor, would proceed to administer final relief. Sec. 106. Dower. Exclusive jurisdiction in equity. In course of time, jurisdiction in equity ceased to be merely ancillary, it becoming the settled practice that courts of equity had concurrent jurisdiction in cases of legal dower, or dower in legal estates. In England, under the Statute of 3 and 4 William 4, ch. 105, equity assumed an exclusive jurisdiction over claims for dower in equitable estates. Where the husband had merely an equity of redemption, the widow could proceed against the mortgagee by a bill in equity to redeem. So could the widow proceed against partnership property where the affairs of the partnership are much delayed, and where the husband has by fraudulent conveyances endeavored to defeat his wife's dower, she may seek relief in equity. Sec. 107. Statutory remedy for dower. The present remedy provided by statute is for the assignment of dower by process in the probate court as an incident of the administration of the deceased husband's estate, or the widow may prosecute an independent action in the common pleas court. This is regarded, or designated as a statutory law proceeding. In some states it may be regarded as exclusive, wherein all relief, equitable or legal, may be granted, as occasion requires. Sec. 108. Forcible entry and detainer. In early common law it was asserted by some authority, and denied by other, that a person having the right to enter upon land could do so by the use of such force as was necessary to accomplish such purpose. To remedy the evils resulting from such forceful entries, a statute was enacted which provided that none thenceforth make entry into any lands or tenements, but in cases where entry is given by the law, and in that case not with strong hand, nor with multitude of people, but only in a peaceable and easy manner, and if any man do to the contrary, and thereof be duly convicted, he shall be punished by imprisonment of his body and thereof ransomed at the king's will. Another statute provided a speedy criminal remedy for such wrongful entry which was within the jurisdiction of the justices of the peace. And finally by statute passed in 1429, 8 Hen. Vi. c. 9, a civil remedy of restitution on inquisition by a jury was provided for. It is the same remedy, practically, as now prevails in this country. Sec. 109. Writ of partition. In code practice, partition is regarded as a statutory proceeding. At the time of the adoption of the code, partition was not considered to be within the meaning of the new code civil action, because it was not classed as one of the common law actions supplanted by the new action created by the code. This view was afterwards modified by judicial construction, partition being regarded as a civil action. Partition as it existed in the common law system strictly was neither a proprietary nor a possessory action. It was a remedy pursued by a tenant in common or a co-parcenus so that he could possess his share, separately from his co-parcenus. It was a writ at common law for the partition of realty owned by tenants in common. Tenants in remainder could not pursue the remedy, the writ being confined to those in possession. Anciently the word partition was employed only with reference to a division of lands by parceners or coes which had descended to them by common law. It was afterwards extended by statute to joint tenancies and tenancies in common, and included not only estates of inheritance, but also estates for life or for years, and estates in which some of the co-tenants held for life or years and others held estates of inheritance. By reason of the early restrictions placed upon the remedy as it was pursued in the common law system of procedure, and before these were removed by statute, resort was had to equity. It is said that courts of equity assumed jurisdiction in partition very early, although its exact origin seems to be uncertain. As early as the reign of Elizabeth, partition became a matter of equitable cognizance. The reasons advanced for resort to equity in such case, are mere convenience, or discovery in aid of some legal right, although the true ground is said to be the inability of the common law courts to furnish a plain, complete and adequate remedy. Equitable jurisdiction in partition was concurrent with law. In this country the remedy has universally been provided for by statute, which preserves all features of the remedy present in the common law and equity systems. While statutory, it is classed as a legal rather than an equitable proceeding.